Hi, I'm Laura Strauss, the host of the Fine Line podcast. They swore to heal, the law swore to protect. But when somebody falls through the cracks, who answers for it? Welcome to the Fine Line podcast. There's a fine line between a system that fails and a person who takes the life of others, between a diagnosis missed and a life dismissed. This is the fine line. Please walk that line with me. Again, my name is Laura. I'm your host, and it's a pleasure to actually start this podcast and be with you all today. What can you expect from this show? The Fine Line is a show about cases that sit where the law, both criminal and civil, medicine and ethics collide. What I try to do differently and what my main goal and focus is to look at cases that are at specific inflection points. Cases where I think there may be changes in the law, or at least the way the jury will focus on certain facts and interpret the law. I welcome you to come and sit in the discomfort with me because this will be uncomfortable. I want to ask what a jury is actually going to have to consider in deciding what a diagnosis can and can't tell us about culpability. I've spent my career pursuing, defending malpractice litigation. And I can tell you from my perspective what a civil jury is being asked. And that's a different question entirely than what a criminal jury is being asked, even when they're both looking at the same set of facts. And here we have two parallel cases that will do just that. That's the fine line this show is aimed for. It's not a metaphor. It's an actual uncomfortable legal boundary between somebody who is criminally responsible and someone, because of their illness, legally isn't. Today, we are walking through one of the hardest cases I've followed in a very, very long time. And I've followed many cases. But before we start discussing today's case, as I've alluded to, I am a medical malpractice attorney. I've worked on both sides of the table. I've represented plaintiffs who brought suits against providers they believe failed them. And I've alternately defended physicians and health systems against exactly those kinds of claims. Probably more importantly, I'm a mom. I'm a mom of a teenager and two young girls. What I'm not. I am not a criminal law expert. And despite my field, I am not a medical professional. I do know a lot about medicine, but I'm not a medical professional. And I will never claim to be either one of those things. So what to do in a situation like that? I am so happy to be able to introduce experts in those fields to you, and they will be my guests on the show. They will help us walk through the difficult and nuanced issues that will have to be faced, both through the criminal law lens, the medical provider lens. Now, welcome. Welcome to the Lindsay Clancy case. Welcome to a discussion of the before, the during, and the after, because every story has a beginning, middle, and end. The before. So before I get into any courtroom, any lawsuit, any diagnosis, I want to spend a few minutes on who Lindsay and her husband, Patrick, actually were before all this happened, because it matters. It matters for the insanity defense you'll learn about. It matters for the malpractice claims you'll also learn about. And honestly, it matters for how we as an audience are supposed to sit with a case like this. Lindsay and Patrick were married in December 2016. Over the next several years, they had 3 children, talked about in length because they are at the center of these claims. Cora, born in December 2017. Dawson, born September 2019. And Callum, born in May 2022. They settled in a home on Summer Street in Duxbury, Massachusetts. It's a coastal town about 40 minutes south of Boston. By every outward account, this was not a family anyone was worried about. But what does that even mean anymore? Lindsay, well, she worked as a labor and delivery nurse at Massachusetts General Hospital, also known as MassGen. That is one of the top hospitals in the country. Patrick, he worked in the home office. Friends describe them as normal, enviable. Privately, though, privately, we know that something had been brewing from. According to accounts Patrick later gave police, Lindsay's anxiety started about the end of September 2022. It's tied to her upcoming return to work at Mass General after having her third child's accountant. She saw two different psychiatrists. She was initially diagnosed with generalized anxiety disorder, not postpartum psychosis, not anything that would have been flagged as high risk. Between October and January, she was prescribed 13, count them, different psychiatric medications for diagnoses of anxiety, depression, insomnia. Patrick Wilkie publicly, specifically in an interview with The New Yorker, said that he didn't consider his wife dangerous and he never treated her as such. He did describe trying to get help. He told police she insisted on being hospitalized in December 2022. As of January 1st, 2023, she was admitted to the inpatient program at McLean Hospital. She stayed. She didn't go in and out. That would have been outpatient. McLean Hospital is one of the most respected psychiatric institutions in the country. You'll learn more about that institution later in future episodes as well. She was discharged 5 days later on January 5th. And in the weeks after the discharge, this is by Patrick's account, he asked her directly if she was still having suicidal thoughts. She told him no. But 2.5 weeks later, on the evening of January 23rd, he went out to pick up some takeout so the family could have dinner. There may have been some calls to get medication as well. That's the moment where the before ends. I'm not telling you this part of the story to build sympathy or to build suspicion. Either one on its own gets ahead of what we actually know. I'm telling you this because the entire legal fight that's about to play out, both in the criminal courtroom and in the civil suits, turns on the difference between these two things. And that's a woman who, from the outside, looked like she was managing a hard but routine transition back to work. And I use routine loosely. And a woman who apparently was deteriorating in ways that 13 medications and a 5-day hospitalization didn't catch and couldn't properly fit. That gap's the fine line. And before we get into what happened during the jury, I wanted you to sit with who they were. We're talking about humans. We're talking about a mom and a dad. But we're getting to the jury. And the jury is the most difficult part to digest. In January 2023, Lindsay allegedly took the lives, and I'm intentionally not saying killed, the 3 young children, 5-year-old Cora, 3-year-old Dawson, and 8-month-old Calvin, before she attempted to take her own life by jumping from a second-story window from her own home. We're here today, so we know she survived, but she's been paralyzed from the chest down since. She was charged with 3 counts of first-degree murder. She was also charged with strangulation originally, but those were dropped by the prosecution just this month. They were deemed to be redundant to the murder counts. She's pleaded not guilty. Her defense has said from the outset that she doesn't dispute what happened physically. The argument here is entirely about her state of mind. They're pursuing an insanity defense, and that's built around this postpartum psychosis. Jury selection begins. The case is being heard in Plymouth Superior Court. The judge, William Sullivan. 18 jurors are going to be seated. 12 plus 6 alternates. We know that alternates are just as important as those seated. Because comes a point in a trial where one of those jurors can no longer sit on a jury, they will be replaced by the alternates. Attorneys estimate that the case will run from 4 to 6 weeks. Here are a few things worth flagging for context before we go any further. So the judge denied a defense motion to let other mothers who've experienced postpartum psychosis to testify about their own symptoms. The court found that that kind of testimony was relevant to Clancy's specific mental state. Her husband, Patrick, he's going to testify in her defense, for the defense, even as he simultaneously is suing her former healthcare providers. That's the Manuel case. That's my jam. And if there is anyone out there who wants some primary sourcing for all of this, you can definitely see the public docket, Commonwealth of Massachusetts versus Lindsay Clancy. I will link the case number below. You also know that I'm sure you're aware that Court TV has been tracking the pretrial rulings in detail. Boston.com, CBS Boston definitely have credentialed courtroom coverage of the hearings. And we ourselves are going to try to see if we can have some firsthand accounts as well. I'm going to drop all the links of that in the show notes. So now we're in the after. What is the after? It's the litigation. It's the suits. It's the Commonwealth versus Lindsay Clancy. Like you said, she's facing 3 counts of first-degree murder for the murder, the alleged murder that took place on January 24th, 2023, resulting in taking the lives of her 3 children. Her defense counsel, Kevin Reddington. Again, what's his theory? Because we always have to have something that wraps our case up in a nice little shell. What we're presenting to the jury, our theory, what we'll be proffering all our evidence towards. So he's pursuing an insanity defense. We talked about this. What's he arguing? With the help and assistance of all of the witnesses that he will ultimately call. He's arguing that she lacked criminal responsibility for the killings due to her mental state. So, specifically, Clancy has said she struggled with postpartum mental illness as well as auditory hallucinations following the birth of her youngest child. That is something many mothers out there can relate to. Reddington has argued that she was over-medicated. Remember those 13 medications? And that her life was horrific misery because of the medications. Well, the defense has a theory, so does the prosecution. What's the prosecution's theory? Assistant District Attorney Jennifer Sprague, she paints Clancy as a cold and calculating killer who executed her children, 1 by 1. Alleging she purposely sent her husband Patrick out to run errands that night, giving herself time to kill the children and attempt suicide. Notably, the prosecutor is female. I do think that that was intentional. I don't think that it was a fact that was not considered. Some important procedural points, and I know we're not going to be, getting into the nitty-gritty of the procedural points, but things that are relevant to where we need to be, painting the framework, giving you a picture of where we are. Venue motion was denied. Venue is where the case is being heard. And Judge Sullivan said, I'm denying the defense motion to move the case to Suffolk County. That's a different county in Massachusetts. He ruled that pretrial publicity about this case, which has been significant, hasn't tainted the jury pool. Second, a bifurcation was denied. So Judge Sullivan denied the defense's request to split the trial into 2 phases, guilt and criminal responsibility. Why? Well, the judge ruled that the evidence and witnesses for both phases would largely overlap. There's a 911 call. Prosecutor sought permission to play to the jury Patrick's 911 call. The judge said he needs to listen to the audio, but was inclined to allow it in full. There would be a jury questionnaire. Judge considered a short written questionnaire focus on the psychiatric and medication-related issues, given the complexities of the case. there could be a possible home visit of the Clancy home. It's not been decided as of yet. And we know that Lindsay's physical condition is one of being severely paralyzed, and she is currently hospitalized in the Tewksbury State Hospital since the killings. She's being transported by van, quite meticulously, to and from the hospital to the courthouse every day. The first in-person appearance happened back in February 2026. And then we come to the ever important witness list, right? They're going to form the basis of the evidence to support these theories that we've been talking about. Mr. Reddington, defense counsel, has approximately 50 witnesses on his list. Of course, he's acknowledged that there will be a significant overlap between his witnesses and those of the prosecution. Most importantly, Patrick Clancy, as I've mentioned, he's on both lists, expected to testify for the defense. Really, most notably, and I want to talk about very directly and very importantly, Patrick is supporting his wife. He is quoted in the New Yorker as saying, "I didn't marry a monster. I married somebody who got sick." That could be the tagline of the Fine Line podcast. Where are we headed next? Well, we talked about the criminal side of the case. It's my expertise. It's the civil side of the case. This is where it gets a little structurally unusual. There are two civil cases. Both of them were filed at the beginning of the year, January 2026. Both of them in Norfolk Superior Court. Both of them centered on the same underlying claim that Lindsay's mental health providers failed her. The first claim was filed by Patrick, and in his own right, as the administrator of the children's estate, he names the psychiatrist, Dr. Jennifer Tufts, a nurse practitioner, Rebecca Gelada, Astor Mental Health, and South Shore Health System. What does it allege? It alleges wrongful death, conscious pain and suffering, gross negligence, and separately, there's an allegation for a HIPAA-related privacy violation against South Shore Health, and that's tied to an employee who allegedly improperly accessed Lindsay's medical records back in 2020. In substance, here's what we know about the negligence claim. The providers prescribed a rapidly escalating combination of powerful psychiatric medications. What? Prozac, Ambien, Remeron, Klonopin, Seroquel, Valium. This is just a few among others. And they were prescribed without adequately coordinating her care or monitoring how she was responding. The suit says that some of her appointments, even as she was reporting her suicidal ideation, so her suicidal thoughts, lasted around 17 minutes. Imagine if you were talking to a mental health professional and it was limited to 17 minutes. As a result, they're alleging inadequate care. And more likely than not, that had there been adequate care, their children would be alive today. So 2 days later, Lindsay files her own separate malpractice suit against these same providers, making a parallel argument and that they negligently worsened her condition. So her filing references a bipolar disorder diagnosis as part of that history. Both suits, both of them, describe a woman who's tried to get help. We talked about this before, admitted herself to McLean Hospital in early January 2023. And this was after she reported suicidal thoughts. She was discharged weeks before she took the lives of her children, and only 5 days after her admission. Both lawsuits frame this as a system that had a chance to intervene and didn't do so effectively. From a legal standpoint, what's notable is that these civil cases don't have to prove insanity. They only have to prove negligence and causation under an ordinary malpractice standard, a much lower standard than the criminal insanity defense requires. So, where do we stand? It's entirely possible for a jury to convict her criminally, while a separate jury later could find that the providers were civilly liable. Those are not contradictory outcomes, but they're different legal questions being asked. So here's some food for thought. Where we are today parallels one of the most historic cases that's hard to avoid discussion of. 2001, Andrea Yates. She was a Texas mother who drowned her 5 children in the family bathtub. She had a documented history of postpartum psychosis and severe postpartum depression following her earlier pregnancies. This also included, and here's a parallel, a prior psychiatric hospitalization and a suicide attempt. Her first trial, that was back in 2002. How did it end? In a conviction for capital murder. This was later reduced on appeal, and the conviction was overturned in 2000 after it emerged that a key prosecution expert had given testimony that was actually he had referenced an episode of Law and Order that didn't actually exist and described it to support his argument that Yates had known right from wrong. So there was a retrial. That happened in 2006. The jury found her not guilty by reason of insanity. At that point, she was committed to a state mental health facility rather than prison. So where are the parallels here? They're hard not to see. Both cases involve moms with clinically documented histories of severe postpartum psychiatric illness. That can't be ignored. Both involved a defense built entirely around an insanity standard, not a factual dispute about what happened. Both involve the extraordinarily high bar that standard requires. And in most jurisdictions, including Massachusetts, the defense has to show that the defendant lacked the capacity to appreciate the wrongfulness of the act, not simply that she was mentally ill. And in both cases, there's a real gap between what a psychiatric diagnosis tells us and what a legal insanity standard requires. So someone can be profoundly ill, found to be psychotic, delusional, disconnected from reality. These are all diagnoses. And a jury can still find that they understood, in some legal sense, that what they were doing was wrong. Gap is exactly where the fine line we're named for exists. So where do these cases diverge? That's instructive too. The Yates case became a turning point for how postpartum psychosis is discussed publicly and legally. But I think this case will take it to the next level. It's an inflection case. We're at an inflection point. It's often cited, the Yates case rather, is often cited as the reason that there's awareness of the condition, postpartum psychoses, and that it's a conversation that was brought into mainstream conversations. The Clancy case adds a layer to the Yates case. It's this parallel civil theory that shifts some of the blame onto the treatment system itself, not just onto her individual state. That's a distinctly 2020 framing, informed by 2 more decades of case law, public understanding around medication management, and provider liability. So whether Massachusetts jurors reached the same conclusion the Yates jury did, this is what this trial is going to test. This is what our discussions are going to be. This is why we're following this case so closely. And whether a negligence claim against her provider actually succeeds is a separate, quieter story that will likely play out over the next few years. And those claims rather, will largely be outside the media spotlight because right now, the issue is obviously the criminal trial. This is the fine line we're walking. This is an important conversation to have together. There is a lot to discuss here, a lot to follow here. And I hope you're just as interested as I am to see where we end up on this issue as a community, as a society, as moms, as dads, as healthcare providers, as lawyers, as experts, as medical professionals, as you and me. As we get into jury selection this week, or further discuss what insanity actually means, legally, otherwise, what we need to see from the defense for the defense theory to work, what we need to see from the prosecution for the prosecution's theory to resonate. I'm excited to take this journey with you. Thank you for joining me today. I know today was a bit dry, but we needed to get through